Even the best lawyers in Virginia and anywhere else in the country will often decline to represent both the driver and the passengers in a car crash case. Why is that? It would seem it would be very efficient to represent everyone in the car in the same accident. Same police report, same pictures of the scene, same investigation. And while that is true, there's a problem. Lawyers take an ethics oath, an oath to follow the rules and code of ethics that say, first and foremost, you shall avoid a conflict of interest. And in many car crash cases, the innocent passengers may have a claim against the driver if the driver of their own vehicle was at fault. Yes, the driver of the car that struck their vehicle may have been speeding, may have been running a red light, may have been doing a number of very bad and unsafe things. But if the driver of their own vehicle was going a little bit too quickly, or not paying attention, or in many rear-end collision cases didn't have their brake lights on or was applying their foot to the brake such that they were illuminated, there may also be a claim against the driver of the car in which the innocent passengers were injured. That is why even the very best lawyers will often say there's a potential conflict of interest. We cannot represent the 3 or 4 passengers and the driver. The rules of ethics allow a lawyer to represent the driver when it appears that there is no conflict, only when there's notice and an opportunity to be heard. That is, where they notify the parties that they would like to represent everyone, and then they get permission. They get permission from the passengers to do so. If the passengers do not give permission, that lawyer should not be representing the driver as well, and the driver should probably get their own legal counsel. We as lawyers are told to avoid even the appearance of impropriety, sometimes called the smell test. If it doesn't look right or doesn't smell right, don't do it. So there have been a number of cases in my own career where it would be very, very advantageous and very, very efficient to represent everybody in the same car. And I've said no. And I've asked the driver, before we meet and before we get into the facts of the case, to secure their own legal counsel to protect their interests, because the innocent passengers that I do represent may have a claim against them for causing part of the accident. The jury instructions in Virginia, the law in Virginia says specifically that you can find at fault a defendant who was not the cause of the accident or the only cause, but in fact a cause, which means you can have more than one defendant responsible for the same accident. We all remember the television commercials involving Reese's Pieces. One of them said, "You got peanut butter on my chocolate." The other one says, "You got chocolate on my peanut butter." Well, under Virginia law, they are both a cause of the Reese's Pieces. Likewise, while the speeding driver who ran the red light and crashed into the 3 passengers and their driver may be the major cause, the predominant cause, even the overwhelming cause, if the driver of the vehicle with the 3 passengers was even going a few miles over the speed limit, didn't have its lights on, or was in some other way unsafe, that driver may also be found to be a cause of the accident and may be held liable for some of the harms and losses. That is why even the very best and most experienced lawyers may say to the driver, it would be a conflict of interest, there would be the appearance of impropriety, you need to secure your own legal counsel, you need to get your own lawyer if I'm going to represent the passengers who are harmed in this crash.